I often get asked, what is the difference between a will and a revocable living trust? In a will, you specify who gets your stuff. Same thing with the revocable living trusts. So what's the difference? To understand the difference, I want to make sure you first appreciate what a big deal it is when you need to transfer the ownership of a titled asset from one person to another. Think about when you closed on your house. Even after the price has been agreed on, the inspection all checked out, there is still a big to-do about getting everybody in a room, usually at least 2 attorneys, one from each side, maybe a notary public and a bunch of other people, and there are tons of documents to sign, pages after pages, the title, the deed, all that to make sure that this title transfers correctly from the previous owner to the new owner. It's not so complicated when an asset does not have a title. Say you're selling your bike on Facebook Marketplace or getting rid of that heavy, bulky Dutch oven from your grandma that you never used for years. When you sell that, you get the money, they get the stuff. But when it comes to an asset with a title, like a house, a business partnership, a car, a rental property, a boat, then it's a big deal. At the very least, the owner of the asset has to be there to sign off the title. That is the problem with only having a will, because a will is a set of directions where you want your assets to go to, but it's missing that part of actually transferring the title. It's missing because if I'm dead, if I'm not around, I am not able to sign off the title to the new owner. Because of that, the court has to step in to supervise this transfer of this title asset from me to the new owner, since I'm no longer around to sign it myself. So the court makes sure that my assets are accounted for. The court has to make sure that there's an executor to follow my directions. The court has to make sure that the heirs get the asset that I intend for them. That process, that court supervision, is called probate. And it's usually has a very negative connotation, something to be avoided like the plague, but its intentions are actually very good. It's trying to protect me, it's trying to protect my assets, it's trying to protect my heirs. Unfortunately, it's just that it's very expensive. It can cost up to 5 to 10% of the entire asset portfolio. It's very stressful. You're having to deal with courts and attorneys and digging up documents you haven't seen for decades. Definitely very stressful, and it's so time consuming. On average, it takes about 12 to 18 months to wrap up a probate process. All that time, you have no access to the assets or the funds. Now, the difference with a revocable living trust is that you have already transferred the title of your assets from your name to the trust while you're still alive. Because of that, there's nothing for the court to step in to supervise the transfer of any titles, because it's already been transferred to the living trusts. What that means is that when you set up a revocable living trust, you get to skip probate. You're saving money, you're saving your family from a lot of stress, and the distribution of your assets is much smoother and quicker because you're not depending on court schedules and all the different, T's and I's they have to cross and dots. The revocable living trust would have its own trust directions, and the successor trustee, who is the person that steps in when I'm gone, will follow the directions to distribute the assets. That is the biggest difference between the will and the living trust. In the will, you have to go through probate, whereas In the Revocable Living Trust, you get to skip probate. The second difference is that the Revocable Living Trust is a private affair. It's done by the successor trustee, and the assets are distributed according to the directions in the trust, whereas with the will, because it is a court process, it's a public affair. So anyone can walk into the court and request to see the probate file, which means she'll get to see all the assets that you're leaving behind and all the people that will be inheriting the assets, which means you could be vulnerable to estranged relatives who are trying to claim a piece of the assets, or creditors and opportunists and scammers. It's best leaving such affairs private, which is the case with the living trust. The third benefit is that the living trust gives you much more flexibility in how you want your assets to be distributed. Let me give you an example. When I first created my estate plan, my kids were 18 and 20. They were old enough to carry arms for the United States of America, but definitely not old enough to have the experience of handling a large sum of money overnight. Because I had a revocable living trust, I was able to specify that I would want a third of their inheritance to be distributed to them when they're 30 years old, another third when they're 35, and then another third when they're 40 years old. Another way that you can set up stipulations is, if you value education, you can say that your children have to have a college degree before they get their inheritance. Or if you are worried about your children being under the influence of addictions they might have, you could require that they complete a program before they get the inheritance. It's not that you're trying to be controlling from the grave. It's just wise, because if not, it'd be like lottery winners. You know their stories. A lot of them actually lose their lottery winnings within a few years, and some of them are actually worse off after winning the lottery. You don't want that to happen to your children. And the Revocable Living Trust allows you to set up stipulations and conditions like that. Before I end the video, I want to mention that a very common mistake with the Revocable Living Trust is that someone would pay an attorney and spend money to set it up, and then they don't follow through on the second step of transferring assets from their name into the trust. In that case, then upon death, the assets would still be in the owner's personal name, which means probate will have to step in.